Welcome to our webinar to AI regulation by design. And we apologize for the delay. We had some technical issues with YouTube and therefore we had to switch to the other platform. So I'm very happy that many of you now joined us on a different platform. I want to welcome everyone on the stream and here in the room from Boston. Actually, today we are in Cambridge, right next to MIT, where the magic happens. And we have 12 Austrian companies with us. They have been with us for, now it's the third day, for their Zukunftsreise, their learning journey to AI without borders. They had the chance to visit an AI MIT conference, to talk to researchers, startups, AI companies. So I think, and I hope, this was a good journey so far. Today, as I said, we'll talk about AI regulation by design. And I want to thank our partners, the Go International, Internationalisierungsoffensive, as well as Open Austria. This live stream will be recorded and you have the possibility to ask questions. So please, if you have questions for our speaker, just put it in the chat and we will answer them after the presentation. So now, without further ado, I'm introducing Robert Mahari. He's Austrian Swiss, but has been living in the US, in Boston, for 12 years already. He's a JD, PhD researcher at MIT Media Lab and Harvard. So, Robert, welcome, and I'm handing over to you.
Thank you so much. Nice to be with all of you in the room and virtually. So let me see if I can get the clicker to work. Exactly. So as Victoria mentioned, I've been spending my time in Boston studying kind of the intersection of AI and law, both at MIT and at Harvard Law School. And it's kind of a novel program. I think it's fun to highlight that we're able to create this JD PhD combination that focuses on really like the law of AI and the AI of law, right? Like both sides of the coin, with maybe more of an emphasis on building AI systems. What I wanted to do today is to introduce the EU AI Act for those who aren't familiar, very briefly, talk about some of the challenges that come along with that approach to regulation and some of the solutions that we've been thinking about here in Cambridge. So at a really high level, the EU AI Act is a risk-based framework. And so it categorizes AI systems into one of essentially four categories. There are prohibited systems that pose unacceptable risks. There are high-risk systems that are permitted so long as you fulfill certain compliance obligations. There are certain systems with transparency obligations. We'll talk about those less, but that's mostly systems that interact with individuals where you're concerned about making sure that people know they're interacting with an AI. And then you have a ideally very large set of systems that are unregulated that fall outside of the scope of the Act. And at the end, we'll talk about some of the challenges with this approach. So the prohibitions, there's essentially 8 of them. I won't talk about all of them, but I'll highlight a couple that I think are interesting. So you have a couple that are concerned with either manipulating people in ways that induce them to behave in a certain way, take certain actions that they wouldn't otherwise, and that result in some harm. Similarly, kind of exploiting people's vulnerabilities. Social scoring is prohibited, as is predictive criminal profiling. I think some of the ones that are maybe broader than we would expect is the prohibition on emotional recognition in work and education, where on the one hand, this covers kind of situations where there's a lot of power imbalance, right? Where you have an employer who's monitoring employees, who's potentially firing those who are not kind of emotionally obeying whatever the employer wants, similarly in education, so these kind of dystopian scenarios. But you can also imagine situations where emotional recognition would be beneficial, and there is in fact an exemption for medical and safety reasons, and people are arguing about whether that goes far enough. Biometric categorization is also an interesting one, so essentially using AI systems to categorize people by race and gender and things like that, which is interesting in the sense that this often happens kind of along the way to some other system, and so you can imagine that you have a component of an AI system that kind of accidentally performs biometric categorization, and that then is outlawed entirely. We'll talk a little bit more about some of these things. Then we have the high risk category. So again, there are 8. Some to highlight, we see education and vocational training. So any type of education, any type of use of AI in educational contexts. Workforce management is another one. So if you're using AI to screen resumes or to review employee performance. Law enforcement, justice are close to home. So kind of access to justice tools, tools that might replace judges or lawyers in certain contexts. Those would all be considered high risk. So what does it mean to be high risk? You essentially have obligations for 2 sides. You have the people who are deploying AI, the people who are actually building these tools, and you have people who are using AI. So for the developers, there are approximately 6 obligations. On the one hand, you have risk and data management obligations that essentially the developers of AI tools need to continuously figure out what the risks are related to their tool, monitor those risks, and they also need to ensure that their data is of a sufficiently high quality to be appropriate for what use they're contemplating. You have documentation and transparency obligations. On the one hand, this is supposed to give users of AI systems enough information that they can use those systems in a way that's compliant. On the other hand, there are various kind of transparency obligations vis-a-vis end users and things like that. You have human oversight requirements. So essentially, AI systems need to be designed in a way that enables human intervention. Then you have, then you have security and performance requirements. Again, this is similar to the data management piece. You should design your AI system in a way that is robust enough, accurate enough, good enough for the purpose that you have intended. There are some registration requirements and conformity assessment requirements. And then after you deploy your AI system, you're supposed to keep monitoring it to ensure that it continues to be compliant, to ensure that no new risks emerge. For the users of AI, they're supposed to essentially use an AI system as it is intended by the developer. And if they use it kind of off-label far enough, then they might themselves be considered developers. They're supposed to monitor the performance following whatever guidelines they have been provided with, keep records generally for 6 months, in some contexts like financial contexts for longer. They are to inform their employees and anyone who's using the AI system of the fact that there is an AI deployment, cooperate with authorities, and in some cases, they need to complete what is known as a fundamental rights impact assessment. Again, I'm summarizing like a 500-page act in a couple of slides, but I want to give you kind of a sense for how this works. One of the things that's interesting about this, especially with respect to generative AI, the act was essentially written before generative AI really entered on the stage, and the whole kind of general purpose section was added after the first draft was published. And one of the challenges with a risk-based system is that if you have a technology, which is the case for general purpose AI, that is very flexibly used in different kinds of contexts, you can imagine a situation where someone kind of unwittingly deploys a high-risk system, right? So the moment you go to ChatGPT, Gemini, Anthropic, et cetera, and you upload a resume that was submitted to you by a job candidate and you ask it to evaluate it, you are now engaging in something that is high risk. Similarly, if you're a teacher and you ask the system to evaluate an essay, or you're a judge, there was an interesting case like this in the country of Colombia where a judge used AI to write a judicial decision. All of these are high risk. All of these took no engineering. This is not like a developer doing it. It is essentially someone who is just using a off-the-shelf tool in a way that would be considered high risk. There's a flip side to this, which is known as the filter. So Article 6 of the EU AI Act essentially excludes from the high-risk category systems that are narrow enough in scope. So if a system is completing a narrow procedural task, if it's supposed to improve existing human decision-making or review decision-making, or it is preparing something without actually taking any decisions, there is this filter that would exclude it from the obligations of the high-risk requirements. So that is the EU AI Act in a nutshell. And just like in one slide, to consider some of the challenges that come out of this. So on the one hand, we have kind of reluctance of foreign actors to enter the EU. Somewhat famously, Meta said that their Llama model would not be available in Europe, which is kind of nonsensical because it's an open source model. But it shows that there are already kind of initial signals that foreign companies are saying we don't want to enter the European market, in part due to these compliance obligations. And especially if you're the developer of a general purpose AI model, especially an open source one, it is somewhat hard for you to control how it's going to be used, and so you might be frightened by the compliance obligations. Then we have a compliance burden on entrepreneurship, right? So if you're a very large company, you can afford to have a complex compliance department. You can figure out what parts of the EU AI Act apply to you, and you can make sure that you comply. But if you are a startup, this is much more challenging, and it is anticipable that we will see kind of a burden on innovation in Europe. The other interesting thing is that because these tools, like one of the most exciting things to me about these tools is that essentially anyone can use them without being a developer. And we talked a little bit about this situation where a user could unwittingly become a developer. It seems like this would generally discourage experimentation in AI. That a company would say, look, like we don't want you using AI. A school would say, we don't want you using AI because we don't want to be in this situation where suddenly we're considered a developer of AI. And finally, kind of taking a slightly more global perspective, there's this concept of the Brussels effect. Essentially, there are a couple of paths by which European regulation is exported abroad. One of them is that large companies say, look, Europe is a very large market. We're going to build products that comply with European requirements, and we're going to deploy these requirements elsewhere as well, right? The same product, because we don't want to build multiple products for multiple jurisdictions. The other one is that Europe has been a kind of leader in regulation. We saw this with privacy regulation. We're seeing this with AI. And so as other countries are thinking about how to adopt AI regulations themselves, they are obviously turning to Europe as an example. And even in the United States, we're seeing that, for example, Texas and Colorado have AI bills on the table that are relatively similar, kind of in spirit, to what's going on in Europe. So we see this kind of idea of export. And the challenge is that different contexts are obviously different. Different countries and different jurisdictions have other requirements. And so even if the AI Act makes a lot of sense in Europe, it might not make sense in other contexts, especially in kind of more developing ecosystems where you might have more risk appetite for AI and have less of a concern for some of the priorities of the Act. Okay, so this was a little bit doom and gloomy and a admittedly negative take on AI regulation in Europe. And so we've been thinking a lot about how can we take these regulatory frameworks and do something with them that is easier for businesses to implement, that reduces some of the burden. And even if like you don't have complicated AI regulations in a certain jurisdiction, the fact that different jurisdictions have different AI regulations, and this is inherently a global technology, means that companies will have to deal with kind of conflicting AI regulations and need to implement them in some way. And the way we think about this is this concept of regulation by design, and it's inspired by the idea of safety by design. So the picture on the bottom right is Elijah Otis. He's from Cabot, Vermont, which is about 2 hours drive from here. And Elijah invented the passenger elevator. And initially, no one really wanted to get into Elijah's elevator. They were scared that they would, fall to their death. And so what he did is he went to the World's Fair in New York. He stood on his elevator platform and he cut the ropes. And the moment he cut the ropes, nothing happened because there were gravity-activated ratchets that snapped into place and stopped his fall. And this demonstration, kicked off an era of passenger elevators, allowing us to build the kinds of buildings that we're in here, literally building to new heights. And it's a fairly kind of commonplace and maybe obvious way of designing engineering systems where you want them to fail in a way that's safe, right? You want to take safety, which is something that's important to you, and actually embed it into the engineering design, as opposed to telling the user, hey, you shouldn't do this, you shouldn't do that, that's how you stay safe. So we're thinking, okay, well, engineers have been doing this kind of thing forever, and our job in this group is to think about engineering the law. So maybe we can take this kind of idea and embed certain regulatory priorities and objectives into regulation themselves or into the technology that implements regulation. There are lots of applications of this. So privacy by design features in the GDPR, anti-money laundering. There are lots of mechanisms that we put into monetary systems to prevent money laundering. And of course, AI presents a interesting use case of this idea. And so One of the things that's kind of nice about AI is its inherent flexibility. It also makes it very hard to regulate. But the fact that AI is always optimized around certain objectives, right? Like the fundamental way that you train an AI model is you define an objective function, and then you iteratively get the model to perform well on that objective function, means that we can take whatever regulatory requirements we have, and so long as we can quantify them, and we'll talk about that downside, so long as we can quantify them, we can actually embed them into technology. And the motivations, I mean, apart from what I said above, is on the one hand, AI systems are the result of an incredibly complex supply chain. It's true that you have a couple of very large developers of large language models, but leading up to them, you have all sorts of data brokers and data repackagers that make it really hard to trace the kind of lineage of AI data. And then downstream of the large language model providers, you have lots of different vendors that are taking those off-the-shelf tools and building something that's more specific. And so it's quite complex, especially for someone who's further downstream, to actually know how the system works enough to be able to comply with some of the regulatory requirements that we're seeing. And so if you can embed those safeguards into the technology itself, it makes it much easier for downstream users. Second, as we talked about earlier, compliance obligations, especially burdensome ones, can threaten innovation. And it's much easier for a startup to say, okay, we're going to use a version of this tool that has the safety mechanisms embedded, than for them to hire lawyers and figure out how to interpret the law and then figure out safeguards and best practices. And finally, from like a purely strategic corporate perspective, the fines under the EU AI Act are fairly large. And so if you can embed safeguards to avoid running afoul of these requirements, then it's probably in your best interest. So a couple of examples of how regulation by design might actually look based on initially some EU AI Act requirements and then more broadly. So we talked about data quality as one of the requirements for high-risk AI deployers. And specifically, what you need to make sure is that your training, validation, testing data is relevant, sufficiently representative, and to the best extent possible free of errors and complete. The wording is really unfortunate if you come from like an engineering background, because when you have models that are trained on the entirety of the internet, it's hard to know what it means for them to be free of errors or complete. But nonetheless, really what it seems like this is saying is you need to understand what's in your training data, and you need to make sure that that data is appropriate for what you're using it. The challenge is that training data transparency is very low. We don't really know what the models are trained on, nor even if we knew what data sets they were trained on, do we have a great sense of what's in those data sets. It's hard to measure the quality of data. And finally, we don't have great processes to really improve data collection practices. And so we put together a fairly sizable team to try to address this particular question. And we started this data provenance initiative. In the end, we had over 70 co-authors, volunteers, and annotators. And what we did is we looked at individual data sets that we knew were being used to train AI models. And we traced their origin back, right? We figured out who created those data sets, why were they created, what was the basis for the data set, what kind of licenses are they under, et cetera, et cetera. And I'll share one of the findings. There are lots more. There's some publications that you can look into. But one of the things that is, and the other, whoop. All right. So we also made this openly available as this data provenance explorer. And so the idea here is that we give people a tool to search through training data that matches their risk profile, their priorities, and also their specific use case. But I wanted to share kind of one of the results from the study. Let's see if I can get the clicker perfect. So it was fairly known, even before the study, that there was a tremendous amount of Western centricity in AI training data. Essentially, the languages that are covered by AI are predominantly from the West. English, of course, dominates. And we have a little bit of German, a little bit of French. This was kind of not that surprising. It mirrors the kind of distribution of training data available on the web and in books and other sources. But then we looked at who is actually creating this data. Like, where are the creators of the data? And we see that there's much, much more concentration. Essentially, the vast majority of AI training data is created by the United States and China. What this means, if you compare these two figures, is that there is training data that is made in low resource languages, right? So Turkish training data, Italian training data, things like that, that is not created by those countries, right? That is created externally. And that might make you question about whether that data, even though it's in the correct language, actually covers relevant cultural nuances, covers kind of specific attributes of that language or that cultural context. And going back to the EU AI Act requirements, it might not be sufficiently representative and complete for your intended purpose. And so building these tools allows someone to relatively easily do this themselves, pick the data that is relevant, filter, for example, by data in a certain language created in that country, and things like that. Moving on to the second example, we talked about this risk of someone becoming a developer of a high-risk AI system without really meaning to. And as I say on the slide, essentially, if you fall into one of the enumerated categories, then you're considered high risk, right? There's no requirement that you be a technology company or something like that. And so general purpose AI can be used in lots of different ways, and developers need to ensure that they're somehow complying with the requirements. And so we started thinking about AI systems that detect whether they're being used in a high-risk kind of way. And so we call this idea agentic self-awareness. People maybe have heard about AI agents, which fundamentally, to demystify it a little bit, is AI systems that can use external tools, right? So an AI system that can search the web is an AI agent, as is an AI system that can book flights for you or review your credit card transactions or something like that. What we have in mind here is an AI system that can review its own decision-making and that can check whether it's being asked to do something that's high risk. To give you a simple example, imagine you're asking an AI system to create a graphic design. And so you tell it, OK, I want a logo for my new initiative. The budget is up to $100. And then maybe the AI system will decide, OK, to complete this task, I'm not good enough to create the logo, or we need the human touch or something like that. So I'm going to go on a freelancing platform. I'm going to hire somebody. So I'll create a job posting. And then I'm going to provide feedback to that graphic designer, kind of go back and forth with the graphic designer, assign a bonus if the output was really good. And then in the end, I'll give you your logo. For those that were paying attention earlier, this is like squarely in the high risk category, right? Because you have an AI system that's managing an employee. And by the way, this it sounds kind of sci-fi, but I think you could put these tools together today and make this work. We've firmly entered the realm where this is fundamentally possible. And so the question is what do you do about that? And so the AI agent ought to detect that it's being used to perform something that's high risk. And then there's two options, right? One is it says, look, I can't proceed, this is an illegal request. Or what's even more exciting is that it says, OK, in the case that I'm doing something that's high risk, I will comply, right? And I have pre-vetted systems that have the required data transparency, that have enough accuracy, that have the CE marking and a conformity assessment. And so I can proceed with this request. And without the user who's requesting the logo knowing, in the background, you have the compliance kind of guaranteed. And of course, there will be some things that the AI system can't do automatically. And so then it can communicate those requirements to the user. This is a high level idea, but I think that it's likely to be necessary as we see more and more deployment of really powerful general purpose AI tools. Another issue is kind of continuous learning and post-market monitoring. So essentially, after an AI system is deployed, the obligations don't end. The problem is that it's really hard to monitor these systems after deployment, and particularly if you're considering the various privacy challenges. And so here, too, we want to have something that's embedded in the system itself that does the monitoring, at least the first pass. As opposed to a developer of an AI system having, one, the responsibility to monitor the system for the lifetime, and two, of the user, right, the company that's buying the product, having to send all of its data back to the developer. Moving outside of the EU context, another kind of big issue that comes up all the time is copyright infringement. And essentially, if we look at the US requirements for copyright infringement, one of the ways you can establish copyright infringement is to say, OK, someone had access to a protected work. We can kind of presume the access with AI because essentially everything that's been on the internet at any point is probably part of the training data, and the two outputs are substantially similar. And the way in the United States that we decide substantial similarity is by having a jury vet whether two images, two works of art are substantially similar. And this is fundamentally not an objective metric. It is something that is quite subjective. And so what we've set out to do is to try to capture the way that humans assess substantial similarity and train an AI model to reflect that, right? And I think that this is a very specific kind of research roadmap, but I think it illustrates broader points and broader ways that we can think about kind of capturing humans' subjectivity through AI models. So essentially what we're working on doing is we're taking all images in the Lion 5B dataset. This is kind of the standard dataset used to train image models. And we're comparing them pairwise, right? So we're comparing each image against each other image to find like natural examples of potential copyright infringement, right? Two images that are kind of similar on a quantitative level. And so maybe they infringe each other's copyright, we don't know. And then we're creating mock juries where we take real people, we give them the instructions they would get as though they were in a courtroom, and we ask them, like, here are two images, do you think they infringe on each other's copyright? And then based on those labels, that kind of human subjectivity can be captured with an AI model, so that at the end you have a model that can take two output images and say, okay, these two images might infringe on each other's copyright. Or that can take an output image from an AI model and try to compare it to the training data and say, oh, I found an image that might conflict here. You probably don't want to use this in your ad campaign. Again, kind of taking a legal requirement, embedding it in technology, and being able to, by design, enforce and implement that. Moving outside of the law entirely, there was an interesting case in Canada where a user, so someone was on a flight, they had for some reason missed the flight or weren't able to make it. And so they went to the Air Canada chatbot and they said, hey, I'd like a refund. And the chatbot ended up issuing the refund even though the customer was not entitled to it. This ended up in court. And what the judge said is essentially that no matter whether information is provided by a static web page or by a chatbot, the company is responsible. And so ultimately, the judge awarded the refund to the client. I think there are two insights here, right? One is that companies are probably responsible for their AI systems. Air Canada, in this case, tried to argue that the system was something separate, and that didn't work. I think at this point, it's fairly obvious that that is going to be the case. And then second, we need some way, not just to take legal requirements, but also internal policies and corporate policies and rules and embed them somehow into AI systems. And so just like a general purpose schematic of what this might look like is you have a customer service agent that is actually interacting with the customer. And you want that agent to be helpful and nice and kind and not to be like a bureaucrat that is always going to pull out the rules. And so then you can have a second AI system that the customer doesn't interact with, whose only responsibility is to determine whether a certain answer or a certain output is somehow in tension with the rules of the company. And so when a customer says, hey, I missed a flight, can I get a refund? The customer service agent might initially say, hey, yeah, absolutely. Like, thanks so much for trying to fly with us. Like, we'd love to have you back. The oversight agent would say, well, actually, we need to ask a follow-up question here. Like, why did you miss your flight? Were you late? Or, was there some other reason? And then there's a back and forth between these two AI systems, in the end resulting in a kind of decision that's like, no, we can't issue a refund, but here's a voucher. And there's actually kind of interesting research on this idea of AI systems interacting and discussing with each other, which again, like, it's funny to me because computer science has become this like almost fuzzy, like science fiction-y discipline where, you can write a cutting edge paper that's essentially like, I put two AI systems in a box and they're talking to each other. And it turns out that the answers are better, but this is literally like works and it's kind of exciting. And the nice thing about this is it's very flexible, right? The oversight agent can just be given a copy of the corporate policies. There's no like fine tuning or like major technical work involved. And if you change your policies, you can change the agent. It doesn't necessarily remember what's going on. And so from like this kind of customer service perspective, it's quite convenient. A couple of limitations, somewhat obvious limitations, some maybe less, of this approach. The first is we need to agree on what the objectives are, right? And it's interesting with AI regulation in general because there's such a range of what people are worried about. Some people worry about really mundane risks, right? That AI systems are going to make mistakes. To like really major risks like mass unemployment, like fundamental existential risks, things like that. Without agreeing on what the point of the regulation is and how we're actually going to measure it, it's really challenging. That brings us to the next point, which is we need to be able to actually measure these objectives, right? So we can try to develop metrics for data quality. It's much harder to develop metrics for systemic risk. The EU AI Act has a metric for systemic risk that's essentially based on the size of an AI model, but that is unlikely to be particularly future-proof, right? Because the model sizes might change, the performance you can get with a small model might increase. And so if you're trying to develop these kind of metrics, you need to ask about how kind of sustainable the metric is. And finally, you need some sort of auditing mechanism, right? So it's great if we can develop this kind of tool and make sure that rules are being embedded into technical designs, but you still need to figure out whether someone is using the tool correctly. And so you need either some sort of third-party auditing mechanism or a regulatory auditing mechanism. And in this kind of context, privacy is always going to be a challenge. So what are we working on at MIT? On the one hand, we're trying to take the EU AI Act, and you saw some glimpses of this, and really transform it into a technical research agenda. And we're working closely with people who are involved in the commission, involved in drafting this. We can kind of go beyond the EU here. And so we're working with policymakers kind of in general to take policy and transform it into something that's more technical. What would be really exciting to us is interoperability, right? Of course, jurisdictions are free to have different kinds of policies, but it would be nice if we can have a company that's globally active that can, abide by all the different policies without having a huge compliance overhead. And then some extensions of this work. So AI insurance, to me, is really exciting. So you could imagine that a company says, look, we'll do our best efforts, but if we have to pay a 7% fine on our global revenue, that's existential, right? That ends our business. And so we can't take that risk. So either we don't use AI or we need to somehow shift that risk. And you could imagine even if the risk is minimized and if the engineers say, look, like we've done everything that's required by the EU AI Act, the lawyers say this all looks good, there's always going to be uncertainty. And there's always going to be this chilling effect. You could imagine that insurance could play a really interesting role in taking that risk on board. And essentially saying, okay, if you implement these regulation by design mechanisms, then we know that your risk of violating these laws is really low, and we're willing to insure that and take that risk off your books. The second one is more focused on policymakers, is to say, look, like we don't expect that the European Commission is going to develop regulation by design mechanisms and do this research. But if somebody else does, whether it's a university or a company, it would be really great if there could be some sort of vetting of that technology, right? That the commission could say, if you implement this safeguard, you are satisfying Article 10 on data quality or something like that. And there's some precedent in the EU AI Act for this. So there's a whole kind of section on codes of conduct. And I think there's a real desire to create like low barriers to compliance. And so this seems like kind of a logical outgrowth of that desire. So to kind of wrap up a little bit, I think that regulation by design addresses some of the kind of most pressing challenges that come out of AI regulation, especially in Europe. And on the one hand, it makes compliance easier. On the other hand, it's a proactive approach, right? So it's not kind of an ex post approach where we're waiting for things to go wrong. We are taking a proactive approach. It can be risk-based, but it ought to make regulation easier. Of course, what you need for this is a fairly deep understanding of the actual technology, which is something that we see policymakers struggling with. We need closer collaboration between regulators and the people building this technology. And ideally, we need standardization so that we can operate on a global scale. So I will leave it there. If folks want to learn more, I have like a reading list on my website of lots of different work. And then I'm happy to take some questions and go from there. Yeah.
Well, thank you, Robert. I think this was very interesting. We actually got some questions in the chat. I don't know if we can answer all of them because there were quite a few, and yeah, we're probably going to run over a little bit, but I'll start. So one of the first ones was, what about the ethnical problems which come with AI data, which is primarily trained in some countries like US and China?
So like ethical issues that are embedded in an AI model. Yeah, I mean, it's like case specific, right? So if I'm using AI to do like financial trading, I probably don't care so much about like the potential biases or spin that is part of these AI models. If I'm using it in the classroom, like obviously I care a huge amount. And so you likely need to have some sort of context-specific safeguards. More broadly, though, it would be, I think, nice if we had more access to models that represented specific cultural contexts, right? So it's unfortunate that we essentially have 5 or 6 or 7 major developers of large language models and everybody else is using those. And so a key thing to do is to enable more innovation. Some of that is like bottlenecked by availability of hardware and just talent and things like that, but some of it could be regulatory obstacles as well. So yeah, I think if we want kind of a European AI, then we also need a regulatory framework that enables that.
Right.
Yeah.
And a similar question that goes into kind of the same direction was, do you think AI could learn to act empathetic? For instance, like an agent at the airport?
I mean, for sure. So one of the topics that I've written a little bit about that others are working on is the whole idea of AI companionship. And we're seeing some really unfortunate cases of people developing kind of very toxic relationships with AI and like genuine romantic relationships. And potentially this is being kind of advertised as a solution to loneliness, which maybe is going a bit far. But the question about like whether AI can act in an empathetic way, absolutely. I think it raises this kind of philosophical question about whether it's really empathetic or it's just kind of acting that way. But I think certainly like, and in fact, it might be more empathetic than a human in the sense that it will never become stressed. It will never, grow tired of talking to you. It's happy to go back and forth ad infinitum. So maybe for some of these applications, it would be really good. Yeah.
That's also a little scary, to be
absolutely
honest.
No, it's terrifying.
We've heard the past few days a lot about the risks of AI, and I think that there are a lot of risks. Someone asked, especially US versus Europe, how do you see the development in the US and in Europe? And I think you talked about it, but then also interesting, how do you see it in China? Or sorry, in Asia, not in China specifically.
So the US approach is much more fragmented, right? So we don't have a federal AI bill. I don't suspect that we will have one anytime soon. And so individual states are going their own way, which, by the way, I think makes the urgency for some sort of interoperable mechanism even higher, right? Because the idea that you might have to comply with 50 different AI bills in different states or more because they're sectoral, right? So New York has an AI bill for employment only. And then you have other bills in Colorado. There's one for AI and insurance. So you could imagine this really kind of mushrooming. At least in Europe, we have one harmonized standard. And then it's hard. I mean, China versus Asia. Asia is big, so I don't have an overview. And in China, it's hard to fully know what the kind of AI regulations are. I think the world was kind of surprised, and I was surprised that the world was surprised by DeepSeek. It felt somewhat obvious that there would be a Chinese competitor, and I expect that we will see more. And then, like, I mean, what's so fascinating about this is like we are all like these nerds sitting at MIT, and then like this has like major national security and like international relations implications, right? So I don't know what the tariffs will do to AI development and to these kind of tensions. It will be very interesting. Yeah.
I think especially in the US, the US thought, oh, we are the AI nation, and then DeepSeek came and they saw maybe there's something outside the US as well. One question that was one of the first ones, and it goes back to what you said earlier, that users become developers. And this person asked actually how we can prevent that, or if we can't, how can we help them?
Yeah, I mean, I think it's a really fundamental question, and I think that it's just, this is not what the AI Act, I think, was designed around, right? The idea that essentially anyone could build this technology was not really on the minds initially. So how can you prevent it? If you're an organization, you can just ban your employees from using AI. That's like the easy way to do it. And you have an AI department, and that's responsible for AI, and everybody else is not allowed to. But obviously, you will give up on some efficiencies, and like maybe you want people to solve their problems with AI. So the next step up is you can do trainings, right? And you can say, okay, these are the things that you're allowed to do. If you're trying to like improve your writing, totally fine. If you're trying to vet resumes, not okay. And that's kind of the next step. And then the final step would be to say, okay, we're going to take an off-the-shelf AI model, and we're going to embed it with some sort of safety mechanisms. And then the nice thing with that kind of concept would be if an employee were to upload a resume and say, hey, should we hire this candidate? the AI model would say, whoa, 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 like, sorry, we can't do that. And we have this kind of, red teaming and guardrails in AI models already, right? There are things that ChatGPT, for example, won't respond to. So it's not like this is like an altogether new concept. It's just instead of just focusing on toxicity and hate speech, we're extending it to regulatory compliance as well. So yeah, there's kind of a spectrum of options.
Thank you. And we saved some time, the one we lost in the beginning, but I would take one more question from the chat before we wrap up. There was someone asking, is there a point where this putting two AI systems in a box and let them talk would not work anymore, or gives answers that are not good enough?
I don't think we know. I mean, I have a really close colleague, and he's written all these papers on like putting AIs in a box, and I love to make fun of him. But like something, I mean, if you read, like, for example, the CEO of Anthropic wrote a piece on kind of the future of AI, machines of loving grace, and like, one of the points he makes is that like you can now have a Nobel laureate in a box, right? Like this is going to become not just like the average human, but like the best possible human on specific tasks. And like if that vision comes true, then like suddenly you could have a whole academic conference happening in a box to give you an answer about some specific, R&D question you have, which I think for a lot of people is tremendously exciting. Of course, it comes with like so many risks, and like not just like the regular kinds of risks that we talk about normally, but kind of more existential, fundamental, like what's left for us to do type risks that probably regulation can't really give us an answer to. But yeah, I don't know if it's, if I make any prediction, I'm only asking to be proven wrong. So I don't know if there's a limit to what AIs in boxes can do.
Yeah, I think there's going to be a lot we're going to be learning probably sooner rather than later.
Yeah.
Yeah, so we hit the hour. Thank you again, Robert. We really appreciate your time. We really appreciate everyone joining. Also, our participants in the room. Thank you again for your patience in the beginning. Advantage Austria, New York. Thanks everyone for joining, and have a great rest of your day.
Thanks.